Welcome to Steve and Tamara Explain Corp's Law, the podcast where two entirely self-appointed experts pretend to know more than they actually know about companies, directors, shareholders, and the occasional legal catastrophe.
This is the place where we take the cases, legislation, and big corporate theory ideas you're meant to understand, and then immediately make them sound much less serious.
So grab a coffee, open your textbook, and let's get into today's episode of Steve and Tamara Explain Corp's Law. Hi, I'm Steve.
And I'm Tamara.
And welcome to Steve and Tamara Explain Corp's Law. Perfect.
Amazing.
Nailed it. I didn't mess it up this time. I've been messing it up every single time.
You did just say that it was a silly name off camera, so, I mean...
it is.
It's...
But let's introduce our guest.
Very good.
Yeah.
Hi, Nick. This is Nick, our colleague.
This is our colleague, Nick. Nick, thank you so much for joining us today.
Thank you for having me.
You're a bona fide corporations law expert, unlike me.
Here's a little thing for you, completely unrelated to anything. Nick was my supervisor once upon a time in practice.
Oh my gosh.
Yes.
That's amazing.
That's going back, isn't it?
It's a few years now.
You've really known each other a long time.
Yes. Yeah. Sorry, Nick. He's known me.
I'm enchanted by that.
Yeah.
That's amazing. And Nick, you've done basically every legal career and some non-legal careers that exist.
Yeah.
You've done everything.
I've even ventured into management. Scarred me for life. Never do it again.
Yeah.
And that's why he's with us now in academia. Well, today we're going to be talking about some interesting things. We're going to be talking about how do directors get to be directors? And then how do they stop being directors?
Our discussion of how they get to be directors is a mere precursor to our more fruitful discussion of how we get rid of them.
Yes.
Or how they get rid of themselves.
Or how they sometimes get rid of themselves. Yeah. Okay, so let's, I guess, start with how does one of these people get appointed as director?
You get appointed by director in one of two ways. You could either be appointed by the company or by other directors.
Yeah.
Right. By the company, you mean the shareholders?
That's exactly right. So when we say by the company in anything relating to corporations law, we mean the company exercising its powers through the members.
The general meeting.
The general meeting, that's right. Or through other directors, and they are both replaceable rules.
Right.
So this is an interesting point because becoming a director, the Act gives the company flexibility.
Yes.
How to appoint their directors, okay? As we will see, when it comes to removing them, then the Act is a little bit more restrictive and selective depending on what type of company you are. But that's how you get in.
Interesting. And so a company can choose, we would like to allow the directors to appoint other directors, or we're going to strike that replaceable rule. We're not going to use it. Only the shareholders.
They've got that flexibility in their constitution. Yeah,
but those are the only two ways. You can't have a constitution that says another way of popular acclaim.
No, there's two. Well, being a replaceable rule, the company can, through Section 135, construct a provision that sets out how they appoint their directors, and that could be
popular acclaim.
But who would do it?
Sure,
but who would do it?
My company.
Your company. So that's how.
That's why you don't have one.
Yeah.
Okay, we're feeling sassy today.
Yes.
Okay.
Your comment, Tamara, might become relevant when we come to disqualification.
It's just keep on coming. So 2 ways to appoint.
Yeah, and then of course they're in.
Yeah.
And then the focus of today's discussion is, of course, well, how do they come out?
Yeah.
And they can come out a couple of ways. One obvious way is their term expires.
Yeah.
And that would be dealt with in the Constitution. There may be other ways. For example, they may die. They may lose mental capacity. The Act doesn't provide for that. The only situation that the Act provides for in relation to, say, loss of mental capacity is if you're a sole director, sole shareholder company.
And what happens then in that case? If you lose mental capacity and you are the sole director?
you've got me there. I read.
Excellent.
I read the Act. The answer is it goes to the. I can be corrected.
We usually correct all our errors with
at the bottom of the screen.
Scroll at the screen.
Well, I hope you have a long scroll. The legal personal representative.
Oh yeah. Okay.
Yep.
Yeah. Oh, so you did know.
That's good on the fly.
Yeah. I'd just like to point out as well that neither of us knew the answer.
I'm stretching the brain here. The interesting point is what happens if you're not a sole director, sole shareholder company, and somebody does lose mental capacity? Well, the answer is you need to provide for it in the Constitution, or you may have a problem.
Yeah, they're just there.
So an example of this is the go-to Constitution that we all refer to, because I think it's a good example of a Constitution.
And it's publicly available.
And that's Westpac.
Yeah.
So, for example, Westpac Article 9.13 says that the office of a director becomes vacant if the director becomes of unsound mind or a person whose personal estate is liable to be dealt with in any way under the law relating to mental health.
Yeah. So they've foreseen that possibility and they've thought,
that's right,
we're not taking that risk.
That kind of answers another question that I was going to have, unsound mind, who determines, but, they peg it to the...
That's right, yeah, and then you would have to determine. But the interesting point is, if you don't provide, if Westpac didn't provide for that, I'm sure you could sort it out, but it would be really...
You might have to go through the general meeting and kind of...
you might have to,
when it comes to removal. But you might be stuck for a while.
Is that a ground for removal if the Constitution doesn't provide that we can remove?
Yeah, I guess it depends on the.
Do you keep?
They may be there forever.
Or keep them until their term expires.
Yeah.
So another interesting point is that your Constitution is really a strategic document for a corporation, and you've got to be mindful when you prepare it.
That's why lawyers are useful, because no one else would think of that.
That's right.
That's why lawyers are useful. We found the reason.
Because we always think the worst.
Yeah,
that's it.
We do always think the worst. That's true. Yeah, we're really good at that.
And the other way is resign.
Yeah.
Okay, so I'm appointed for 5 years. 2 years in, I get tired. I want to get out. I resign. The significance of the resignation, though, is it's got to be in writing to the company at the registered office. If it's not effective, then you continue to be. And while you think you're resigned, during that period the company engages in insolvent trading, then you're
potentially liable.
That would be really unfortunate.
Yes, it would. It's very precise. It's got to be to the company in writing to the registered office.
And I think we talked a bit earlier, not in this podcast, you and I talked a bit earlier about the idea that if it's a sole director company, then you can't resign.
No,
there's company without a director.
Void.
Yeah, but also with a proprietary limited company. This restriction doesn't apply to public companies, but a proprietary limited company, if a removal of a director leaves you with no directors, then you can't
remove that. For a public company, they have to have 3 directors.
Yes.
So that rule isn't as necessary. Now I might be testing you again. If you are one of 3 directors of a public company, can you resign even though that would mean the company would no longer have the required 3 directors?
I believe that you can.
Yes.
I believe that you can. Again, we'll fix this scroll. But my memory of looking at this when I was last teaching it was that you can still resign in that instance.
Yes.
But the company has to appoint another director.
Has to appoint one,
as soon as possible.
Yeah. I think you're right. I think not complying with the minimum doesn't restrict you from being less than the minimum, but you've got to comply with
the minimum.
Have to then appoint someone. So, good questions that you're...
Well, it's just interesting because if you breach the proprietary company rules, like the 50 non-employee shareholders and that, you have to convert to being a public company. But there's no, punishment for not complying. I mean, I'm sure there is, but, if you don't have 3 directors and you're a public company, it's not like they're going to convert you to being a proprietary company.
No. This discussion of the different ways of appointing and stopping thus far, we'll get to disqualification soon, is what's really important again, and I think we've said this in the past when we've been doing these videos, it's important to have a list almost of private company, what can they do?
Yes.
And then public company, what can they do? Because otherwise you kind of get yourself a little bit confused. And really, it's very clear once you kind of say, if you're a private company, this is how you can appoint, this is how you can resign, this is how you can be removed, and the same for a public company.
That's true.
I think that's the easiest way.
That's right. Because there are differences.
Yes.
And they're differences that can be easily overlooked.
Yes, that's right. Yeah.
And it goes to the article that we're working on at the moment about how
yes, that's
proprietary
true.
companies and public companies are regulated so differently.
Yes, that's right. Okay, so now I think we're going to continue with a little bit or a related area. What happens when a director is forced to stop being a director?
All right. So there's two ways that directors are forced out, if you like. One is they are removed, and the other one is by operation of law, the statute, they are disqualified.
Both probably not what they're hoping for.
No, but they're important areas.
Yeah.
And some of the most interesting, because that's where some interesting facts arise.
And some of the most interesting. In relation to the removal, that's where you really get the corporate strategy. In my experience in small proprietary limited companies.
Yes.
Yeah, right.
What to note about the removal is both for public companies and proprietary limited companies, the removal is by ordinary resolution of the members. So the company, again, exercises its power to remove.
50% of the shareholders say you're out.
51%.
51%, so of course, then you're out.
Then you're out. The interesting difference is that that is a replaceable rule for proprietary limited companies, but it is not for a public company.
Interesting.
Yes.
Yeah.
So for a public company, the only way that a director can be removed is by a general meeting.
Yeah.
Right.
Okay. And it's not only hardwired, it's sort of hardwired and then cemented in, because it goes on and say any other provision in the Constitution, any separate agreement between the company and directors, void.
Wow.
Okay. So it's embedded.
Yeah.
Okay. With a proprietary limited company, it's a replaceable rule.
Yeah.
So yes, you can, or you can have
any other rule.
You can have any other rule.
Yeah.
You can have other directors appoint.
Yeah.
All right. You can have 25% of the shares.
Yeah.
And that's very interesting because that reflects what I think is the reality. Although the separation of power between directors and the members, the legal separation is identical between the two. The practical separation is very different in proprietary limited companies.
Because they're dealing with two different kind of scenarios, right?
Yeah.
I mean, when you've got the smaller proprietary companies, you've got this kind of personal...
There's no practical separation.
yeah.
The directors are usually the shareholders.
shareholders.
The shareholders are usually the directors.
Yeah.
And if you've started a small private company and you've started it, you may not want to make it easy to be
To be
removed.
ousted.
That's exactly right.
yeah.
And in my experience, the problems have come up with family companies where they're generational, where mum and dad starts it and then they hand it over to the kids, right? And mum and dad step back and they say, well, look, we'll take our dividends out of this, our share, but we don't want to manage anymore, right? But they want to keep a hold on the manager, because if they see the kids are going a little bit haywire,
Then they want to.
yeah, that's right. So they may say, look, we don't want 50% of the shares.
Yeah.
We don't even want 20% of the shares.
Yeah.
But we'll take 5% of the shares, but these shares are going to have certain rights. And one right's going to be, if we reckon you're playing up, we're going to remove you and we'll step in.
And so in my company, could I insert a rule? In my company, could I put a rule in the Constitution that said the only way a director can be removed is by absolute majority of the shareholders?
Yep, or unanimous.
Unanimous. Could I say directors can't be removed?
So life tenure.
Life
I
tenure.
think you can.
I can't see a problem with that.
I don't think that there's anything that says no.
No. I think you're right.
Good to know.
Yeah.
Yeah.
Yeah, but make sure you provide what happens when they do die.
Yes. Right. What would happen in a sole director? Again,
you're
I feel
coming
like
up
I'm-
with the...
Yeah, I'm sorry. A sole,
You need a long ribbon.
a sole director company where the director dies.
Yeah.
Does the company end? If it was one director, sole director,
no,
sole
it doesn't.
I mean, the company can continue, but it would need to appoint a new director.
But how can it if it doesn't have any shareholders because the one shareholder's dead?
If the provision is, and I wish I'd brought that, I didn't want to bring the Act, but
The
I
Act,
brought
yeah.
the Act.
It's too heavy.
The personal legal representative,
Yes.
right,
Yes.
steps in,
Yeah.
right, then that personal legal representative would take over the shares as part of the estate,
Yeah.
and presumably under the will, or if it's an intestacy,
Yes.
would be distributed, so someone would eventually become the shareholder,
the
shareholder.
and become the
Yeah.
director.
Because, I mean,
Yeah.
the share doesn't just go away.
Yeah.
Yeah.
But ASIC could also deregister the company if it had no shareholder and no director.
No, but the share would still be there.
Yeah, it would
So
fight,
someone
yeah.
would
Yeah.
get it.
Yeah.
Even,
Yeah.
You know, yeah.
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 Interesting. Good.
Wow.
You know, I always like to talk about the situation where death occurs. So
I think it's time that you wind up your company.
Yes.
yeah, well,
Okay,
so
so
that's it.
So that's removal, and I think again, removal's really interesting because of that kind of family dynamic in the small proprietary companies. But now we can move on, I guess, to
disqualification.
what happens. So removal's by the company. Disqualification is by virtue of the law.
That's right. That's exactly right. So this is removal is there's a play to get to remove.
Yeah.
Disqualification is because something has happened, and the law says that in these circumstances you are no longer fit to be a director.
Yeah.
And there are three types of disqualification.
Okay.
One is the automatic.
Yeah. Is that like a show cause event for a
No. Automatic. It's a strict liability.
done.
Yeah.
You've just done something in the legislation.
Yeah, that's right. Yeah. Provided an event occurs, then it's strict liability, you're out.
Yeah.
And from the moment the event occurs, you're
done.
No longer a director.
Yeah.
The other one is a disqualification by the court, right, on an application by ASIC. So ASIC says, I have evidence of behaviour prescribed under the Act, which means that you should be disqualified, I take an action.
Yeah.
And then you have the third one, which is a disqualification by ASIC.
Yeah, right.
All right? And that's an interesting one. They're all disqualifications, automatic or brought on, but they all have the same consequences.
Which is that you're disqualified.
From managing a company.
And that's exactly right. So that's the consequence. And if you do manage a company, as defined by Section 206A, then that's an offence.
Right.
Okay.
And they use the term managing rather than direct.
That's exactly right. Yeah, that's right.
Yeah,
that's right. And they derive the language of Section 206A from the common law.
Right.
Where they determine what managing the company means. The words they use, they come out from the case that we have prescribed as reading, Commission of Corporate Affairs and BRACT.
Okay.
Right. So they talk about getting involved in a way that affects the corporation as a whole or a substantial part of the corporation, or making decisions that may have some significant bearing on the financial standing.
Yeah.
Now that's out of the judgment, but if you go into the section,
it has
you see those.
analogous wording.
And it also provides for shadow directors.
Right.
Yes.
So if your conduct is what we understand to be a shadow director, that is also.
And that will be an offence then.
That's exactly right.
Yeah, they're trying to avoid this situation where you say, well, I wasn't, appointed
I wasn't a
as a
director.
director.
Yeah.
It'd be exactly the same thing.
Yeah.
So we know that there are three ways to be disqualified, and they have the same consequences.
They have the same
you can't
consequence.
manage
Yeah,
the company.
yeah.
And so if we look a little bit more in detail into the three, the automatic one, there's the sections, I believe, outline a couple of instances where if you fall under those, then you just disqualified without the need for anything else.
That's exactly right. Yeah, so that's Section 206. And they are relate to offences.
I believe is one a bankruptcy as well.
That's right. Yeah.
Yes.
Yeah. So I'm sorry. I've got convictions.
Convictions.
One's convictions.
Yeah.
Right. Both indictable and non-indictable.
And I believe is it 5? You're then precluded 5 years from either the end of your sentence, or if there's no sentence, the time
from
of the conviction,
or the end of your sentence, 5 years. And ASIC can apply to the court to extend. Bankruptcy is another one. Yeah, you were right there. If you've been disqualified from managing Aboriginal and Torres Strait Islander corporations,
Right.
and foreign court orders that disqualify you as a director.
Right.
Yes.
So as we said earlier, if one of these events occur, it's done.
Yeah.
So that's why I described it as strict liability.
So conviction of any offence, indictable or non-indictable, disqualifies you.
That's right, yeah.
Interesting.
Yeah.
I guess it makes sense.
I mean, it
we don't
does.
want people that are convicted to. Yeah.
Yeah.
And within there, and within those sections, you have reference to offences that relate to dishonesty.
Yes.
So it's fairly broad. And if they're going to ping a director, it's important to know which one.
Yes.
Then you're not just looking for a conviction.
Yeah.
You're looking for a conviction in relation to a particular
Offence.
offence. And it includes offences under the
Corporations Act itself. Yeah.
It's interesting because, as you know, I also teach legal ethics. And so we have like all of the tests for being a fit and proper person as a lawyer. And bankruptcy is a show cause event. So if you become bankrupt as a lawyer, you immediately need to show why you should still be able to practice, why you're still fit and proper. It doesn't automatically disqualify you, and neither does being convicted of an offence. Can still be fit and proper. You You won't always be.
But that's an interesting point, whereas here it's strict liability.
It's done.
As opposed to a court application by ASIC.
Yes.
Now that,
Which is the second
which is the second one.
Yeah.
So with this one, you've got prerequisites.
Yeah.
You've got them to have done something.
Yeah.
Right? So there has to be, for example, a declaration of a contravention under section 1317E. So that's a civil penalty provision.
Yeah.
For example, that's one of them. There's several others, but you need that. Or breach the civil penalty provision under the corporations of Aboriginal and Torres Strait Islander.
Yeah.
You need those, but that's not enough.
Okay.
Okay. Then the court has to be satisfied that the disqualification is justified.
Right.
Okay.
Yeah.
And that's where you get the cases, the famous cases, the Adler case and the Camper case.
Adler's particularly useful.
Well, yes.
Because almost every section that you can think of in the corporation.
That's exactly right, isn't it? He's done it all.
Covered
He's done
in
it
that
all.
case. So if you want to read just one case, everything.
Yeah, and probably there's stuff there that wasn't even contemplated.
That's right, yes.
Yeah, without going through it, the court has to address its mind under section 206C. C2, and then we have these cases that guide
as to when it's appropriate and justified.
And including the length.
Yes.
Yeah.
And that's Justice Santo, I believe.
Yeah, Santo.
Sets out the factors
that's exactly
you
right.
Consider.
Yeah.
You probably have them there, so I won't get them wrong because I remember some, but not all of the factors.
I've got them all here.
You've got them all there.
Amazing.
I think if we had Oscars for this podcast,
Yeah.
Nick would win the
He
most prepared.
Is so prepared. It's the best.
So what are some of the key ones?
All right. So general propositions. Longer periods of disqualifications are reserved for cases where the contraventions have been serious, so dishonesty.
Yes.
Balancing the personal hardship to the defendant against the public interest, and the defendant's likelihood of reforming is a mitigating factor for consideration.
And I think that he's got other things in there, like, lack of remorse and stuff like that.
Yeah.
Like, you don't really understand that you've done something wrong. I mean, this kind of makes sense that if those are the circumstances in the case, then you're going to get the longer disqualification.
And those he takes from the Camper case, character of defenders, nature of the breach, structure of the companies, etc.
Yeah.
What's interesting, though, is that Santo makes the point that the purpose of it is to protect
the public.
Yeah, but it's not intended to be punitive.
Yes. Yeah.
This is a view that's a little bit different to what the High Court said in Rich and ASIC, where the court said protective proceedings can also have the effect of punishing. The defendant.
It's kind of a little bit obvious, isn't it?
Yeah.
Like, if you're protected, it kind of ends up being a punishment because...
Well, if you're saying to someone you can't do your highly lucrative job anymore, you're no longer allowed
over
to
25 years. It's ends up being...
But I think the point there is the court is asked to consider whether it is satisfied that the disqualification is justified.
So it's not like the court could say or should say, the reason that we're going to disqualify you for this length of time is because we want to punish you.
That's exactly right.
What they would say is, we believe that this length of disqualification is justified in order to protect the public, and the High Court was saying, well, that can also have a punitive effect.
Yeah, that's right. Yeah.
So you can see kind of already the difference between the automatic, where it's kind of like, these are just stated, if you do these, you're out.
Yeah.
Whereas if you're ASIC applying to the court, it's not as clear cut. Yeah. It's these circumstances exist, and we think that it's therefore justified. Yeah. But then there's a third option, which is ASIC just does it on its own.
That's right. And if you look at section 206F, the very obvious difference is one is a judicial process, and the other one is an administrative process. But they are very, very similar.
Right.
Yeah. All right. So you have the threshold requirements. There have to be certain events. In the case of ASIC can only disqualify for 5 years.
Right.
Whereas the court
can do any time.
What you have to have is that you have a person who has been an officer of 2 or more corporations, and while they were an officer, they failed.
The companies,
and the Act defines what failure is. And if you go through, it's a list, but we're looking at insolvency. And then within that period, you give them notice, and given the
then they can-
opportunity, and ASIC is satisfied that the disqualification is justified.
Okay.
Yeah.
And so they'll be judging that themselves.
That's right. Yes.
So you almost have, if we were thinking of these in order, I would go automatic, clear cut,
Yeah.
certain circumstances. Then you've got a decision for ASIC.
Yeah.
If it doesn't
That's
fall
right,
there,
yeah.
they kind of say, do we go it on our own? Have they failed twice? Do
Yeah.
we give them
That's
a notice?
exactly right.
Relatively clear cut.
Relatively
Yeah.
clear cut.
Situation again.
If not,
Yeah.
then they can decide
That's
to
exactly
go to court
right.
where they have to show justification for the
That's exactly. And what's really interesting is in Merdaka and ASIC, the court actually described Section 206F as a quick and cheap alternative to the court.
Yeah,
to
right.
the court
Yeah.
proceedings, right?
Yeah.
Yeah.
Oh, I don't know how
I
ASIC
mean-
feels about that.
Well, it is really,
It
if you
is.
think about
It
like
is.
keeping it out of court, that's
Yeah.
good. But, and of course, it's an administrative decision, so it can still be appealed.
Yeah, the decision can be appealed,
Yeah.
but the decision to issue a notice
Cannot be appealed.
Cannot be appealed.
Yeah.
Cannot be appealed.
But that's the power of the regulator to regulate. Yeah.
Yeah, so that's the disqualification.
Yeah.
How's that?
That's an excellent summary.
Yeah.
Yeah.
Really comprehensive.
Really comprehensive, yes. Befitting the notes.
Yes. Yes. The excellent notes.
And the highlights.
And the highlights,
Yeah.
yes. Okay,
but
thanks
no
for that.
annotations, though.
There were earlier. I was.
Okay.
Yeah.
Yeah. Well, there we go.
All right, thanks for that, Nick. That was
Thank you
really
so
great.
much.
Fun. Thank you very much. I really enjoyed it. Thank you. Thank you.